is Paymon Ramju, and at our firm, we empower, educate, and advocate for those seriously injured in auto accidents. We oftentimes get the question by our client as to whether or not they should file the case or go to court. And it's a good question. Sometimes we get settlement offers prior to having to file a case, and it becomes an important consideration of whether or not the time and expense and uncertainty of filing a case makes sense. So today I want to take just a little bit of time and walk through some of the pros, some of the cons, and just the landscape in which cases proceed if they do ultimately get filed with the court. And I want to first start off by saying this. The courts have often said that whether or not you're represented by counsel, whether or not you have an attorney, you're treated to the same rules that attorneys are. And it can be an unfair advantage for someone to be represented by counsel when the other party is representing themselves. I've seen it in court where somebody who represents themselves tries to admit exhibits or tries to call witnesses. And unfortunately, they do not know the proper ways to do it, and they're limited in what they're actually able to prove to the court. It can be really an unfortunate, stressful situation for someone who doesn't know how to handle cases in the courtroom. And I will say Missouri laws are complicated. Just give you one example. Missouri has a pure comparative fault law, which means that although an accident may have been caused by a number of factors, that even if the person bringing the suit shares some fault in the accident, they can still recover. And it can be a difficult fact pattern and be difficult evidence that may need to be obtained and presented to the court in order to try to show the jury who is actually at fault and to what percentage each person may be at fault. We know that insurance plays a role in the way cases are resolved. There are sometimes cases that are resolved for the most amount of insurance coverage that exists prior to having to file the case with the court. And sometimes for strategic reasons, we may say that we've collected everything we can and there may not be any other avenues and it may not be worth filing. But there's of course a bunch of reasons why it may make sense to file a case. And let's just talk about a few of these. For one, there are sometimes cases that involve very serious injuries. You may have situations like traumatic brain injuries, amputation, catastrophic injuries. And unfortunately, insurance companies don't always see the injuries in the same vein that we want them to or that our client has suffered. And it can be necessary in order for the insurance company to be forced to compensate our client to file a case, in order to show them the significance of the case, the seriousness that we're treating it with, and ultimately the long-term effects that our client has had to endure. Also, it may be important to file a case due to the amount of insurance coverage. Sometimes we do have cases where, unfortunately, there's insufficient insurance coverage. And there may be reasons why we had to file a case to get a judgment, maybe affecting property or trying to find other ways that we can put liens against certain things so that in the event we have insufficient insurance coverage, we still can use that judgment in order to collect against the person who caused the injury. There's also things like the Tort Victim Compensation Fund. And so there's some practical reasons why filing a case may make sense due to the low or no coverage that somebody may have who's caused the accident. A common reason where insurance isn't willing to resolve a case or where the party who is at fault won't resolve a case is when there's disputed liability. This, of course, can happen in any number of situations, but just to illustrate a point, imagine you have two cars coming up to a four-way stop sign. And let's imagine that one of the cars fails to stop and goes through the intersection. And let's also imagine that the other car involved in the accident doesn't fully stop at the intersection. And so maybe you have a dispute as to who should have stopped, whether both parties stopped as long as they needed to stop. And maybe there's some confusion as far as who should be responsible for the accident. Sometimes in situations like that, it's necessary to file the case because although we want the other party to believe and to know that we're not at fault for the accident, sometimes they're not willing to. And sometimes the evidence that they have may be contrary to the position that we want them to hold. For those reasons, we do have to sometimes file cases just simply because we have disputed liability. The truth is this as well. We do have many situations where the insurance company is giving unfair or low settlement offers. And we believe that one of the best ways to make sure our clients get fairly compensated for the injuries that they experience is to show the insurance company that we're willing to go the distance. We're going to file the case, we're going to do what discovery needs to be done, and ultimately we'll be prepared to try the case in front of a jury. One of the best ways to get insurance companies to take you serious is to file a case and to be willing to take the case all the way to a jury if necessary. There are complicated laws surrounding requirements that insurance companies have to negotiate in good faith. And there are some times where cases have to get filed because the insurance companies have failed to fulfill their responsibility. These cases are called bad faith cases. And for several reasons, it can be necessary to file a case in order to obtain a judgment to show how unreasonable an insurance company has been prior to the court's intervention. The process in Missouri as far as filing a case is like this. The very first thing that you have to do is you have to prepare a complaint or a petition. In that petition, you have to list the counts or the allegations in which you're bringing forth that constitute the cause of action that you have. So, for instance, if you were to file a negligence case, you would have to include facts in your petition which bring forth the basis of your request. Once that petition's on file, then there's some steps required as far as service and making sure that everybody's on notice that the lawsuit is filed. Oftentimes, once a lawsuit's filed, the next phase is what's called the discovery phase, in which documents and information is exchanged between the parties. Sometimes people are thinking that there's surprises in the courtroom. And certainly while there can be some surprises as far as how a witness presents or how they answer, for the most part, the information prior to trial results in a lot of disclosures or information being shared so that by the time you actually get to court, most people know exactly what's going to take place. Often discovery leads to the next phase, which is mediation. The courts have a strong favor towards settlement. They want the parties, if possible, to be able to reach meaningful resolutions so that they can avoid the cost and potential uncertainty of trial. And while I may disagree about the productivity of mediation, it nonetheless is often a part of the case that we'll participate in after discovery has concluded. Finally, after a case has been filed, after discovery has been done, after potentially the parties have mediated, the case will then go to trial. Trial is ultimately in front of a judge or a jury where the underlying dispute is heard about and where decisions made as to what to do about what took place. There are some significant factors that clients have to consider when deciding to file a case or not. And one of the things that we do have to consider is the cost of litigation. It can be expensive for our clients to hire experts, for our clients to have to pay for depositions. And while we advance all of these costs, it nonetheless are costs that get reimbursed if we're successful on a case. Also, trial is time consuming. It can be more than a year before we even get a trial date after a case is filed. And the time spent between depositions, discovery, and actually sitting in trial can be really consuming. There are some clients that just don't have the time to manage everything required in order to prepare and actually try a case. So it's a consideration that we have to take seriously and talk through with our client if we're heading down the path of trial. There are some people too that just find it too emotionally taxing or stressful to be involved in litigation. And it can be true that testifying can be a nerve-wracking process. Talking in front of public is many people's first or second stressor or fear. And it can be, of course, frightening to do the same in front of 12 jurors. So the emotional strain of trial is important for us to consider, but it's also important that we sit with our client, we walk them through the process, and we familiarize them with what's to come so that they feel comfortable, they know what to expect, they know what's going to happen. Now, another reason that we have to be considerate of trial is because the outcomes that can take place at trial are far-reaching. It's possible we lose, it's possible we win, and it's possible any combination in between as far as what the jury will do is for damages for our client. So we'll try to do everything we can in litigating cases or being in trial with cases to prepare and make sure that we have done everything we can to make sure our trial is going to be successful for our client. In conclusion, I'll say this. We have a strong favor towards filing and litigating cases. It's where I truly believe that we can obtain full compensation for our clients. There are a lot of reasons why there's been a push towards settling cases, but I find that there are even more reasons why we should go the distance and be willing to stand by our clients and try cases. I will tell you this as well. Anytime that we work with our client, they're given every option and they're made aware of why they may choose one or another. One of the primary tasks that we have at our office is to educate our client so they can make informed decisions. And they can decide whether or not it's best for them and their case to move forward with trial, to file a case, or to settle a case before even having to file the case.